1st July 2024, that's when 3 laws passed by the Parliament last year will come into effect. 3 critical laws that will completely change the way India's criminal justice system works. From registering an FIR electronically to death penalty for mob lynching and even stricter punishment for gang rape. These laws bring in several changes to our criminal laws. The government says these new laws are a bid to replace the colonial-era criminal laws. But these changes, arguably huge in scale, has been met with some resistance. Some members of parliament want these laws to go back to parliament for discussion again. West Bengal Chief Minister Mamata Banerjee has written to PM Modi seeking the implementation of the laws to be deferred. A plea has been filed in the Supreme Court on Thursday seeking a stay on the implementation of these laws. Constitutional experts, jurists, and activists too have pointed out certain practical challenges that may come in the way. So what are the changes in store and what are the concerns being raised? Hello and welcome to Simply Put. I am Shubham Chohan. Let's get started. Now before we speak about some of the big changes, here's a quick background. In 2020, a committee was formed by the Home Ministry to recommend quote-unquote criminal reforms in India. A draft was introduced in Parliament in August 2023, following which that bill was sent to a parliamentary committee. In December 2023, the final version of these laws was passed in both houses of Parliament. That was the winter session of Parliament. Yes, the same session where we saw a record suspension of members of Parliament. These laws that apply to the entire country and have severe ramifications were passed in Parliament in the absence of more than 140 MPs. Many point out that these codes didn't see sufficient debate in Parliament as should be the case. Because mind you, the basic job of the legislature or the Parliament is to frame laws through a consultative process. Speaking about the laws, Home Minister Amit Shah said these laws have an updated and Indian framework of criminal laws compared to the colonial era.
माननीय अध्यक्ष जी, एक तीनों कानून अंग्रेजों के जमाने से बनाए थे। जैसा मैंने कहा कि 150 साल पुराने कानून। मोदी जी ने प्रधानमंत्री बनने के बाद गुलामी की मानसिकता और गुलामी के सारे चिन्ह इस देश में से जल्दी मिट जाए और नए आत्मविश्वास के साथ महान भारत की रचना का रास्ता प्रशस्त हो, इस पर आग्रह रखा। उन्होंने लाल किले की प्राचीर से कहा, मान्यवर, उन्होंने कहा कि कॉलोनियल कानूनों से जल्दी इस देश को मुक्ति मिलनी चाहिए और उसी के तहत गृह मंत्रालय ने 2019 से इसमें परिवर्तन लाने के लिए गहन विचार विमर्श चालू किया था।
So what really changes now? For starters, the name itself. Until now, the criminal laws that were in place were the following: the Indian Penal Code of 1860, the Code of Criminal Procedure or CrPC of 1973, and the Indian Evidence Act 1872. Now these 3 laws will be replaced by Bhartiya Nyay Sanhita 2023, Bhartiya Nagarik Suraksha Sanhita 2023, and the Bhartiya Suraksha 2023. I know it's a mouthful. So let's take the changes one by one. The Nyay Sanhita will have 358 sections compared to its predecessor, which had 511. 20 new crimes have been defined and the extent of punishment has been enhanced in 33 crimes. The Nagarik Suraksha will have 531 sections instead of 484 earlier. 2 new chapters have been added here, and the Bhartiya Suraksha law will have 170 sections compared to 166 previously, and 24 provisions have been amended here. Now let's look at the content itself. In the Nyay Sanhita, the definition of terrorism has been expanded. So now, in addition to acts which attack India's unity, integrity, sovereignty, now threats to economic security and monetary stability have been added as well. Next, there is mob lynching. Hate crimes and mob lynching have been categorized as separate offences under the Nyay Sanhita. It has been defined as the following: when a mob of 5 or more people murders someone based on race, caste, community or belief, that is what has been defined as mob lynching. This crime can lead to a maximum punishment of death penalty. Previously, the IPC did not have a specific definition on this. Instead, an offence of murder was usually registered in such cases that had death penalty or life imprisonment. Then there is sedition, a law that has made headlines, especially post-2014, for alleged misuse. Between 2014 and 19 alone, out of the 326 sedition cases filed, only 6 people were convicted. Now, under the new law, the offence of sedition itself has been removed, but the new code does talk about penalizing acts endangering the unity and integrity of India. Rajdroh, which is basically acting against the government, has been changed to Deshdroh, which means acting against the country. Maximum penalty in this case is 7 years in jail. So technically, sedition as a crime still remains, contrary to what the Home Minister claimed, that the law has been removed completely. It's just that a few words have been tweaked here and there. Then, in crimes against women, the new law has made the punishment stringent. In the case of rape of a minor girl, life imprisonment and death penalty can be given. A gang rape could lead to 20 years or imprisonment for life. Next, the new law allows for police custody for 15 days in whole or in parts at any time in the first 40 to 90 days of investigation period, depending on the crime itself. Now, this wasn't the case earlier, where in the first 15 days of detention, the custody could be changed from police to judicial and vice versa. Experts have pointed out that the new provision may shrink the possibility of an accused getting bail. Now, there are some other additions as well. I'll quickly go through that, like community service being introduced as one of the punishments for the first time. The Nagarik Suraksha Sanhita talks of trial and judgment within 30 days of completion of arguments. Video recording of statement of sexual assault victims is mandatory. Then, in the Indian Evidence Act, documents will also include electronic records, emails, smartphones, etc. And digitization of all records, including case diary, FIR, charge sheet, and the judgment itself. Now let's come to the concerns being raised. And that's a more basic question to begin with. What about the matters pending in court already? The sections and charges all belong to the old criminal laws. Now, post 1st July, when the new laws kick in, which law or sections will be applicable to a crime? If applied retrospectively, many say this could lead to massive confusion and even raise questions on the rights of the accused. Like senior advocate Indra Jai Singh, who said, and I quote, "The basic concern is during this entire period, what is happening to the accused? The accused will be in custody. Okay, where is the guarantee that while all this is being clarified, that is the use of laws, the accused will be on bail? There is no such guarantee under the law." Next, is our system prepared for such a big overhaul? Because mind you, a drastic legal change requires it to be percolated right down to the lowest officer or official. Have administrative officials or even the police been adequately trained about these new laws? As per a report by Scroll's Vineet Bhalla, some police officials in and around Delhi said they received minimal classroom training for only a few days and they were still coming up to speed with the new provisions and the requirements. With just a few days left for the implementation, all eyes will be on how seamless this process is, because this change will not be an overnight thing. Such a process will take months, if not years, to actually smoothen out and ensure that the entire system is in sync. Until then, constitutional experts say this raises a big question mark on what's in store for India's criminal laws. That's all we have for this episode of Simply Put. Do comment and let us know your views. That's all we have. Thanks for watching.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.